The Bill of Rights. The Bill of Rights has changed very little through the four constitutions of Kentucky. With few exceptions, the provisions presented below are the same ones that were included in the 1792 Constitution of Kentucky. The Bill of Rights in the present Constitution of Kentucky contains 26 individual sections, most of which were carried over from the 1850 Constitution. Actually, the Bill of Rights has had few changes since Kentucky became a state in 1792. The Bill of Rights provides a guarantee for liberties and rights traditionally found in a Bill of Rights, including that of the U.S. Constitution. Rights included in the U.S. Constitution are such guarantees as freedom of speech, press, assembly, and religion, property rights, the right to bear arms, free emigration, free elections, trial by jury, freedom from search and seizure, grand jury indictment in felony cases, the right to bail and habeas corpus, and prohibition against ex post facto laws. Impairment of contracts, quartering of troops in peacetime, involuntary servitude, bills of attainder, and titles of nobility or hereditary distinctions. In keeping with the lengthy and detailed nature of the Kentucky Constitution, the 26 sections of Kentucky's Bill of Rights covers several pages of ordinary type. In contrast, the Bill of Rights in the U.S. Constitution is contained in 10 short amendments which can easily be written on one page. Advocates for a new constitution in Kentucky have not been inclined to alter the Bill of Rights, although the Constitution Revision Assembly proposed in 1965 that 3 sections be added to provide, first, that a person accused of committing a felony could waive the right to grand jury indictment and go to trial on the basis of information supplied by the prosecutor. Second, that a material witness could not be held in prison to ensure his appearance in a case. And third, that electronic or other mechanical interception of communications should be prohibited. Although some purists contend that a lengthy, detailed listing of the people's rights is superfluous in a state constitution, because of the nationalization of rights under rulings of the United States Supreme Court, it should be pointed out that protecting the average citizen's rights in state courts under a state Bill of Rights is a quicker and less expensive procedure than going through the federal courts. Intended to secure individual liberties and to limit the right of government to encroach upon those liberties, the Bill of Rights has changed little since being incorporated into the first Constitution. The rights found in the original Bill of Rights remain essentially the same, with religious freedom and the separation of church and state having been somewhat enhanced in the current Constitution. The framers of the Third Constitution added 2 provisions to the Bill of Rights, one of which was retained in the current Constitution, that being the denial of absolute and arbitrary power. A full 27 of the 28 sections of the original Bill of Rights were taken verbatim, or nearly verbatim, from the Pennsylvania Constitution of 1790. Many of the same liberties also appear in the Federal Bill of Rights. While Kentucky courts have generally not enlarged upon federal rights, in some notable exceptions such enlargement has occurred. Finally, although the language of the Kentucky Bill of Rights has not changed much, its location in the Constitution has. The framers placed the Bill of Rights first, not last as in the previous constitutions, in order to emphasize the importance of individual liberties. As is the case with its federal counterpart, the Kentucky Bill of Rights has been the most frequently litigated part of the state constitution.
Preamble and Section 1. The preamble to the Bill of Rights is identical to those found in the first 3 constitutions except that the word general, which appeared before great, has been deleted. The drafters of the first Constitution took this language from the Pennsylvania Constitution of 1790. It reads, that the great and essential principles of liberty and free government may be recognized and established, we declare that rights of life, liberty, worship, pursuit of safety and happiness, free speech, acquiring and protecting property, peaceable assembly, redress of grievances, bearing arms. All men are, by nature, free and equal, and have certain inherent and inalienable rights, among which may be reckoned. First, the right of enjoying and defending their lives and liberties. Second, the right of worshipping Almighty God according to the dictates of their consciences. Third, the right of seeking and pursuing their safety and happiness. Fourth, the right of freely communicating their thoughts and opinions. Fifth, the right of acquiring and protecting property. Sixth, the right of assembling together in a peaceable manner for their common good, and of applying to those invested with the power of government for redress of grievances or other proper purposes, by petition, address or remonstrance. 7th, the right to bear arms in defense of themselves and of the state, subject to the power of the General Assembly to enact laws to prevent persons from carrying concealed weapons. This section summarizes the basic rights that individuals possess and may exercise without unreasonable governmental interference. Most of these rights were also guaranteed by the previous three constitutions. The introductory sentence of this section did not appear in the previous constitutions and is a synopsis of similar language found in the Declaration of Independence and the Virginia Declaration of Rights of 1776. The first subsection, the right of enjoying and defending their lives and liberties, the third subsection, the right of seeking and pursuing their safety and happiness, and the fifth subsection, the right of acquiring and protecting property, appeared in the previous constitutions as duties of government rather than rights of the people. The language for the first subsection came from the Massachusetts Constitution of 1780, and for the third and fifth subsections from the Virginia Declaration of Rights of 1776. The remaining four subsections existed as separate sections in the previous three constitutions and were originally taken from the Pennsylvania Constitution of 1790. Kentucky's Constitution of 1850 added the concealed weapons clause of the seventh subsection in response to a Court of Appeals decision holding unconstitutional the Commonwealth's first statute, which prohibited the carrying of concealed weapons, in Bliss v. Commonwealth, 1822. Section 1 of the 1891 Constitution is phrased differently, but the provisions are much the same as appeared in the preambles and other sections of the 1792, 1799, and 1850 constitutions. The Kentucky Supreme Court has cited the introductory, inalienable rights, language of Section 1, together with the first subsection, the right of enjoying and defending their lives and liberties, and third subsection, the right of seeking and pursuing their safety and happiness, as a partial rationale to expressly find a greater right to privacy in the Kentucky Constitution than that found by the U.S. Supreme Court in the federal Constitution.
Section 2. Absolute and arbitrary power denied. Absolute and arbitrary power over the lives, liberty and property of freemen exists nowhere in a republic, not even in the largest majority. The framers of the Constitution of 1850 added this section as an attempt to guarantee that no future legislative majority would emancipate Kentucky's slaves without compensation to the slave owners. Although there was an effort to delete this section from the current Constitution on the grounds that it was an obsolete relic of the days of slavery and only stated a truism, the delegates voted to retain it as a necessary restriction on the potentially absolute power of the legislature.
Section 3. Men are equal, no exclusive grant except for public services, property not to be exempted from taxation, grants revocable. All men, when they form a social compact, are equal, and no grant of exclusive, separate public emoluments or privileges shall be made to any man or set of men, except in consideration of public services, but no property shall be exempt from taxation except as provided in this Constitution, and every grant of a franchise, privilege or exemption, shall remain subject to revocation, alteration or amendment. The first two clauses of this section appeared with slightly different language in the previous constitutions. The framers of the current Constitution added the third and fourth clauses. In the original form, the first clause resembled those of other contemporary state constitutions and declared widely accepted political theory about the inherent equality of men, most especially white adult men. By the date of the fourth and last constitution, however, this language was beginning to have the potential to grant a measure of equality to all men and women regardless of race or gender, although it would be some time before that condition would be constitutionally encouraged. The second clause also appeared in the Virginia Declaration of Rights of 1776 and may have been taken from that document. It seeks to prohibit individuals or groups of individuals from securing from government benefits that are not granted in receipt of public services. By 1890, many Kentuckians complained that in the charters, the legislature had granted special privileges and tax immunities to a significant number of corporations. Although the U.S. Supreme Court had made it easier for states to revise or revoke corporate charters, reformers wanted to ensure that this could be constitutionally accomplished in the future by the legislature and other agencies of state government. Thus the constitutional reformers inserted the third and fourth clauses in order to curtail special corporate privileges, including tax immunities. The current Section 3 was Section 1 in the three previous constitutions. The latter part of Section 3, which specifies no exemption of property from taxation and the right of revocation of grants of privilege, was added in 1891. These provisions reflect the desire of the convention delegates to prevent the abuses of special legislation that had occurred prior to 1891. See the section on the legislature for further details of this issue.
Section 4. Power inherent in the people, right to alter, reform, or abolish government. All power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, happiness, and the protection of property. For the advancement of these ends, they have at all times an inalienable and indefeasible right to alter, reform, or abolish their government in such manner as they may deem proper. This provision, which was taken almost verbatim from the Pennsylvania Constitution of 1790 and appears in all four constitutions, embodies a basic theoretical legacy of the American Revolution, the idea of republicanism, or the theory that all governmental authority is derived from the people, who may change and even abolish their government if they so desire. The framers of the Third Constitution added the phrase, "and the protection of property," doubtless having in mind mostly property in slaves. The language found in Section 4 of the Constitution is quite similar to that found in the writings of the British political philosopher, John Locke, and also in Thomas Jefferson's Declaration of Independence.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.